Happy Monday, and welcome to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about novel charter claims. Cases that should have gone to the Supreme Court of Canada, but didn't. Two former youth in care in Alberta were receiving financial support and benefits after they aged out of the foster care system. Pursuant to legislation in Alberta, they were eligible for these benefits up until the age of 24. However, Alberta changed legislation and eliminated the benefits beginning at age 22, and these two former youth in care were cut off from their financial benefits and support. As a result, they filed a lawsuit against the province of Alberta, alleging that their charter rights had been violated in that they had been discriminated against based on age. They had also, of course, unnecessarily been cut off from support that they had counted on the basis of an arbitrary age cutoff. And this was the basis of their charter claims. It was a novel issue, having never been considered in Alberta before. And as a result of the fact that they were no longer receiving funding from the government, they applied for injunctive relief, essentially to stop the government from putting 22 as the cutoff age until the determination of whether or not their charter rights had been violated was made. The original court granted their application and prevented the government of Alberta from imposing the 22-year-old cutoff age, but the government appealed, and the case was overturned at the Court of Appeal for Alberta, which determined that the test for injunctive relief had not been made out, primarily because the balance of convenience for the province of Alberta was more favorable to them, because otherwise, of course, there'd be all these 23 and 24-year-olds that they would continue to have a fiduciary obligation to continue to have to support. And so it was more convenient for the government of Alberta to continue to have the legislation function the way they wanted than the way that the children wanted. There was also a presumption applied in the circumstances of the case, which was the core of the issue in dispute in the determination of the appeal. And this was the presumption of public purpose, or good public policy, that applies to charter infringing or allegedly charter infringing conduct or legislation passed by a government. There is a presumption at the test for injunctive relief stage that the legislation was passed in good faith and that the government had a legitimate purpose in mind in passing the legislation the way it did, even though it might be the case that in a case such as this, the legislation was passed just because the government wanted to save a few bucks and didn't want to support children anymore. These are significant issues that the Supreme Court of Canada had to consider. Whether when it comes to charter infringements where there's a novel charter infringement being considered by the court, whether it was appropriate for the court to consider the test for injunctive relief and determine that the public purpose of the legislation was presumed to be there. It's not as though there's other infringements, like a driving legislation that's obviously aimed at public safety and you can connect the public purpose, and it's not really novel law to say that there should be some charter infringements when it comes to the issue of driving. This was charter infringements based on age for children who were in the foster care system and to whom the government, up until the point that they changed the law, owed a fiduciary obligation. So obviously this raises a significant issue, and the Supreme Court of Canada really missed the opportunity to make things more fair for people who are negatively impacted by decisions that government make by just creating and affirming with its silence a blanket presumption that the government is always doing everything for the best motives, even though we know that that's not always true, and history has taught us, particularly in the last 18 months, that that's definitely not always the case. The Supreme Court of Canada had an opportunity to right a wrong here, and to prevent two children who had already been through a very difficult system and had started to age out of that system, to prevent them from being just cut off from all of their support that they had up until that point been counting on. Isn't that more important in the injunctive relief consideration than anything else? Hopefully the Supreme Court of Canada has another opportunity to revisit this issue, because novel charter litigation is not that common, but when it occurs, it's important enough that a new lens on the test for injunctive relief should be considered. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.